In this series of lectures, we'll discuss about passive euthanasia and why we have titled it as passive euthanasia because it is being legalized by the Supreme Court of India and permitted legally for passive euthanasia after the landmark judgment that was delivered by the apex court in 2018 in the important leading case common cause a registered society versus Union of India. The bench was presided by the then Chief Justice of India, Justice Deepak Mishra. So, the very question that phrase regarding right to die with dignity and whether this particular right to die with dignity, whether it falls under right to live with dignity. So, as the very question that relates to right to die with dignity, whether it falls under right to live with dignity, that comes under the constitutional provision under Article 21, which provides right to life and personal liberty. So, the very question that revolves around for the last 3 decades or more than the last 3 decades, which started in the very landmark judgment that was delivered by the Bombay High Court in the year 1986 in the Maruti Sripati Duval versus State of Maharashtra case, and where the Bombay High Court decriminalized and declared unconstitutional very section that deals with attempt to suicide under the Indian Penal Code, and that is section 309 of the Indian Penal Code. So, when it comes under passive euthanasia, as we know, whenever one is facing a terminal illness or who are in irremediable pain and suffering and wish to exercise their right to die with dignity, and such system should be available to them as it was found. So, in particularly in India, as regarding right to life and personal liberty, it is a fundamental right which is enshrined in Article 21 of the Indian Constitution. And the very provision expresses that no person shall be deprived of his life and personal liberty except according to procedure established by law. While this fundamental right primarily focuses on the preservation of life, it has also been interpreted by the judiciary to include the right to live with dignity. However, the question arises whether this right extends to the right to end one's life or the right to die. So, the very concept of death, especially voluntarily, when it was assisted by any person, normally a physician or a surgeon, so qualified and registered under the Indian Medical Council Act, who would assist in that suicide or euthanasia it always conflicts with the social values, cultural values, and those legal norms developed and established by the statutes and the constitutional provisions of India. Historically, legal systems have equated death with the unlawful act of suicide, which has been penalized under Section 309 of the Indian Penal Code. In spite of that, medical advancement and philosophical debates revolved around that, where law has started to recognize scenarios where euthanasia or the right to die may be justified. So, now we would like to discuss what exactly euthanasia means and what are the different types of euthanasia. So, now we'll discuss in particularly what exactly euthanasia means and how it was legalized and what are the arguments in supporting euthanasia and the arguments against euthanasia. So, in particularly, euthanasia is a practice where a person's life is deliberately ended to relieve them of suffering, typically in cases of terminally illness. So, euthanasia can be divided into two particular categories. One is active euthanasia, and the second one is passive euthanasia. So, active euthanasia means where a third party actively administers a substance to end a person's life, and such persons are physicians, doctors, or surgeons who are qualified in the medical ethics entitled of being providing and prescribing proper treatment to save the life of a person, and when they failed and they advise in case of ending one's life, and that would be called as active euthanasia. And wherever it is passive euthanasia, it means the life support system given to a patient or a person terminally ill when there are least chances of recovery of that patient or person, then the life support systems are withdrawn to allow the person to die naturally, and that is called passive euthanasia. So, now we'll discuss those arguments in support of euthanasia, and in particularly the first supporting argument is in favor of that it relief from suffering. The second one, it serves financial and emotional relief. Then also regarding medical ethics. So, in case of relief from suffering, as it provides an option to end extreme physical and mental pain in terminal conditions of a patient or a person admitted into an hospital, and where it is financial and emotional relief, euthanasia can ease the financial burden and emotional stress on families caring for terminally ill patients. And regarding medical ethics as a supporting factor for legalizing euthanasia, it aligns with physicians' duty to alleviate suffering and help patients die with dignity. And now we'll discuss the arguments against euthanasia, and in particularly on the grounds of religious objections, then the potential for abuse, then involuntary euthanasia. So, when it is religious objections, we found that many religious beliefs oppose euthanasia, asserting that life is sacred and should not be prematurely ended. And the second argument against euthanasia is that it is potential for abuse, as legalizing euthanasia could lead to misuse, especially involving vulnerable groups like the elderly or senior citizens or the poor. And the third argument is relating to involuntary euthanasia. There is a concern that legalizing euthanasia may eventually lead to involuntary euthanasia, where individuals could be coerced into ending their lives. And now we'll discuss about the landmark judgments, and in particular regarding those landmark judgments. The first most important landmark judgment in the legal and constitutional history of India was in the year 1986, wherein particularly that was the landmark judgment delivered by the Bombay High Court, and that was Maruti Sripati Duval versus State of Maharashtra in 1986, where the Bombay High Court declared the very section 309 of Indian Penal Code as unconstitutional. So, into that extent, it decriminalized the very punishment provided for attempting to suicide. And the second most important landmark judgment relating to this issue is State versus Sanjay Kumar Bhatia, which was decided in the year 1994 by the Delhi High Court. So, in that particular case, Delhi High Court criticized Section 309 of the Indian Penal Code, which criminalizes attempted suicide, as the High Court expressed in its own words that the very provision of criminalizing attempted suicide as provided under Section 309 of the Indian Penal Code is anachronistic and a paradox. The court recognized the distressing nature of a suicide attempt and called for a more human approach, but it did not provide a conclusive ruling on euthanasia. So, then in the next important leading case, and that is relating to Naresh Marutrao Shakre versus Union of India in 1996, the court drew a distinction between suicide and euthanasia. Suicide is considered as self-destruction, while euthanasia involves the active participation of a third party, ending the life of a person or a patient. The court pointed out that euthanasia was not addressed at all under the very provisions of Section 309 of the Indian Penal Code. And the next landmark judgment, that was relating to P. Rathinam versus Nagbhushan Patnaik. versus Union of India in 1994, where exactly the apex court or the Supreme Court struck down Section 309 of the Indian Penal Code, declaring it to be unconstitutional and irrational. The ruling emphasized the importance of compassion, especially in cases of people suffering from severe pain or terminal illness or mental illness, and the court called for decriminalizing suicide attempts. However, this ruling and judgment of the apex court was overruled in the important leading case, and that is Gan Kaur versus State of Punjab in 1996, where the apex court or the Supreme Court reaffirmed that the right to life under Article 21 does not include right to die or the right to be killed. The Supreme Court held that suicide and euthanasia are inconsistent with the concept of the right to life, as life is a natural and fundamental right as it is guaranteed under Article 21 of the Constitution of India. However, the apex court also suggested that passive euthanasia, which allows patients to refuse life support could be a valid option. And the next important leading case that we would like to discuss is Aruna Ramchandran Sandbag versus Union of India, which was decided in the year 2011. So, in this very landmark case, the petitioner Aruna Ramchandran Sandbag was a staff nurse at King Edward Memorial Hospital at Bombay, and she was strangulated in a dog chain, and ultimately it was by the sweeper of the said hospital. So in that event she almost went in a vegetative state for years. So on behalf of her, a petition was filed by one of her close friends. In this landmark judgment, the Supreme Court dealt with the issue of passive euthanasia, as he was in a vegetative state for years following that brutal assault by the sweeper. So here the apex court permitted passive euthanasia, holding that if a person is in a permanent vegetative state with no hope of recovery, they could be allowed to die with dignity by removing the life support. But before that, the apex court appointed a committee of doctors to inquiry and made suggestion to the Honorable Court regarding the fact of this case, though then the doctors committee submitted their reports, and on the basis of the report it was found that the staff and doctors of King Edward Memorial Hospital are not refusing to take care of Aruna Ramchandran Sandbag. So, in this case, the Supreme Court remained silent and did not permit passive euthanasia to Aruna Ramchandran Sandbag. And finally, the landmark judgment regarding passive euthanasia came in 2018, and that was in that landmark judgment, Common Cause Registered Society versus Union of India. So, in that particular case, in 2018, the judgment by the Supreme Court bench was a pivotal moment for the right to die in India. So, a five-judge bench led by the then Chief Justice of India, Justice Deepak Mishra, unanimously recognized the right to die with dignity as a fundamental right, and it also falls under right to live with dignity. And as it is a part of Article 21 of the Constitution, which guarantees right to life and personal liberty. So also the apex court legalized passive euthanasia and permitted the creation of a living will or an advance medical directive allowing terminally ill patients to express their wishes regarding end of life decisions. So this landmark judgment has been seen as a major step in the legal recognition of euthanasia in India. So now we would like to conclude our discussion regarding passive euthanasia. So in particularly in case of India, the statutes and the constitution. Statutes here in particularly we refer to the Indian Penal Code and the very provision under Section 309 which criminalizes attempt to suicide. Even the Constitution of India does not provide any kind of active euthanasia. So in India, active euthanasia remains illegal. But passive euthanasia was legalized after this landmark judgment delivered in 2018. And now it is a fundamental right. So, right to die with dignity. Now it is a part of right to live with dignity and which encompasses as under Article 21 of the Constitution which provides right to life and personal liberty. So it is now a fundamental right. So as progress has been made in the country, so the concern is about the misuse of this very legalizing of euthanasia. And the very future of euthanasia remains uncertain. However, at present, after the judgment of 2018 in the landmark case, that is Common Cause Registered Society versus Union of India, right to die with dignity now is a part of right to live with dignity, and which in particularly enshrined under Article 21 of the Constitution of India, which provides right to life and personal liberty. And in the successive lectures or in the upcoming lectures, we will discuss in detail all these landmark judgments. So we will start first Maruti Sripati Dubal versus State of Maharashtra, which was decided by the Bombay High Court in 1986. Then we will discuss about State versus Sanjay Kumar Bhatia, that was decided in 1994 by the Delhi High Court. And in particularly, we will discuss in our lecture series which are upcoming or successive lecture series in particular is the very important leading cases relating to euthanasia and right to die or attempted suicide in P. Rathinam and Nagabhushan Patnaik versus Union of India, which was decided in 1994. Then the judgment delivered in 1996 in the landmark case Gankor was a state of Punjab. Then we will discuss about Aruna Ramchandran Sambhav versus Union of India, which was decided in the year 2011. And finally, we will also discuss about Common Cause Registered Society versus Union of India in 2018.